Okay, Ron DeWayne Whitfield, the Texas Department of Criminal Justice Department Parole Division.
So stay right here. Who's your officer?
Her name is T. Robinson.
Miss Robinson?
Roberts.
Just a second. Miss Roberts?
Yes, ma'am.
Okay. What time was your appointment, sir?
My appointment was yesterday. She come to where I live yesterday after my.
I'm trying to get him
No, I'm special.
To do what?
calm down.
Ma'am, it's legal to be excited in the United States. You don't need to be calm.
Okay, sir.
This is the United States.
Okay, you can get out. Go.
Okay.
Get out. Go.
You're not gonna help me?
No, I'll go get Miss
Okay.
Robinson.
Okay. Thank you. Hello.
Excuse me, sir. Yeah, check. Ms. Roberts here? Yes, sir. Talk to him. Excuse me, ma'am. Ms. Roberts here?
Yes, ma'am. Miss Campbell, it's Ron DeWayne Whitfield, 0063668. Sure. Sure. Okay, Miss 623668. Yes, ma'am. Not good. Miss Kim, I talked to you on Friday of last week. This morning, I contacted the Inspector General of the TDCJ to do an official complaint with them as well. I also been in contact with the Texas Board of Criminal Justice as well as the Executive Director of this TDCJ. Now, I made it clear to you all that you all have authority to subject me to any of your control and supervision. Do you not understand that, ma'am? Yes, ma'am. Yes, ma'am.
Hello. This morning,
It purports that Ms. Campbell, we're wasting time on that. Excuse me, Ms. That's not being professional, Ms. Campbell. Ms. Campbell, listen, so you, hold on. But guess who disagrees with you, ma'am? Let me show you. If you allow me, we wouldn't have a problem. Let me show you. I know that, Ms. Campbell. I've been doing this for you as who you were. I've been doing this. Let me, if you want to assist me, you would want to listen to what I'm saying. Ms. Campbell, thank you. But please let me speak so there can be no room for confusion. This is what I'm doing. I'm challenging this agency authority. Do we understand that much? That means unless you can produce a judgment from the Harris County District Court saying that I've been convicted of a crime, you don't have no authority over me. It's just that simple. Now, I just got to talk to the judge's office today. They don't. No, ma'am. No, ma'am. You have to call the Harris County District Clerk and ask them that what you have, is this real? That's what your duty is once I challenge your authority. I thought you knew that. No, ma'am. You have to. No, ma'am. Listen to me, ma'am. Look, ma'am. I'm not a damn fool is what I'm trying to tell you. I'm not a damn fool. Now, listen. You have to contact the Harris County District Clerk office. If they tell you you don't have a judgment and sentence for that so-called offender, that's what that means. Does that make sense? Anytime a person challenges authority, God give me the right to be free. Man gives me the right to be protected in that freedom. So when I tell you you have no authority over my purse, that means you get with your attorney general, and he will tell you what I say is true. Do that make sense to you? Ma'am, I got the judge recorded today. I called the judge where the conviction supposed to come from. You understand? The judge, they don't have a judgment, ma'am. This is a grave problem for Texas. You understand that, don't you? You don't want the American people to know you got all these people out of Harris County in here illegally, do you? So I'm letting you see the United States Attorney's Office. He's telling me how to get y'all. We're going to do this. We're going to go before the magistrate. This is what we're going to do. So when I put you on legal notice and you fail to take action, then you commit a crime. Do you understand that much? So in order to see, I'm talking to you in your public, not private capacity. I'm telling you, I'm not a parolee. When I challenge your authority, you have a duty to call that judge and that clerk office. Ma'am, do you have a judgment on file? If not, we don't have authority over this offender because he's not an offender. So on the recorded line, I made it very clear. I can be no clear. Brandon, get your purse. Let's go back here.
Hold on. Have you finished?
Miss Campbell, on a recorded line, do you understand? Do we understand each other, man? Okay, then that's all I needed to hear. Thank you, ma'am. Goodbye. Hang this up. I'm ready. No, I want my phone. I'm recording.
Put your phone down. Put your phone down.
Put your phone down. Yes, sir. Yes, sir.
Okay. Do you have anything in your pocket? Do you have anything in your pocket? Take off your keys. Your keys, take it off. Because it doesn't need to make any noise. Okay. What else do you have? Resident ship. What is that? This one right there.
My phone.
Come. Face. Turn around, face me. Get rid of your hand. So you wipe that off 16. When you turn up,
Coins.
This is making noise. I know you're there. It makes noise. Take it. Put it here.
Mr. Okay, I'm trying to be reasonable.
No, leave your belt.
But this doesn't come off. And I'm being reasonable.
Okay, let me make sure.
I'm not what y'all call excited.
Let me say
Yes, sir. Oh, I need to call the United States Attorney for Mr. Adam. He said you want to speak to just a minute, Mr. Okay. Tell him you want to speak to Mr. Adam Goldman. Let him know where I'm at.
Mr. Whitfield, are
You want the United States Attorney? Hold on,
Mr.
Mr.
Whitfield,
Martin,
are you
please.
coming back here or not?
Well, he's
We already posted you on the phone. You're gonna be staying right now. Any other calls?
Mr. Adam Goldman.
Yes,
Assistant United States Attorney. No, sir, I want him to hear the conversation. Is this a public building? Is this a public building? Okay, then don't. Let's keep it on the scene where I'm at. I'm being fine.
This thing is
Okay. I don't want to be relaxed today. I want to be just the way I am, sir. Thank you. Right. I'm trying to be relaxed. Okay. So you want me to act different?
Yeah.
Just tell him, tell him, get the operator on the phone.
Is your wife coming with you?
Yes.
Okay, she needs to stand too.
Let her be. Let me join church.
Liberty's party.
Sure.
Call the United States Attorney, Houston, Texas.
Okay, Ms. Whitfield, you ready?
Yes, just let me get back situated.
Go back. Straight ahead. You got everything?
I do, sir. Hello? Yes, I need to speak with Attorney Adam Goldman, please. Mr. Goldman, this is Ronald Whitfield. I'm in the Texas Department of Criminal Justice Department Parole Division, and they've got me undergoing some duress, and I think I'm gonna have to get aggressive and being resistant. And I'm recording them as I stay here, so I need to come see you tomorrow because I want to go ahead and No. I want to go ahead and bring criminal charges with a magistrate tomorrow. Okay. I'm recording, but what I want to do is bring this to the United States Attorney himself. I'm being officially oppressed, and I would like to go ahead and make sure the magistrate allows me to make complaint for probable cause, because this is starting to, I feel myself this is starting to, make me become something I don't want to, so let the United States Attorney know that I'm not going to deal with this in it. I will, with Mr. Adam, I'll be there tomorrow. Okay, let me say this because they're here. This is what my plan would be. I will go to the FBI tomorrow. I will do official complaint with them. Then I will come to you all and do that complaint that you had me to download.
Oh, yeah, we have to make sure we get that in today.
Well, they're oppressing me, and I'm trying to see what this is what I'm saying. I don't want to see this. I'm finna protect. Look, they oppressing me, and I don't want to deal with that no more. So that's why I say I'll go to the FBI, and then I'll come over there because I'm not finna go through this no more with them. So if this is, I want to see where this conspiracy is coming from. So let me go ahead. Okay. Fine. I will. Like I said, I'll go to the FBI first, and I'll come by. Thank you. Hang that up. All right. We're in a hurry.
Mr. Whitfield, now, I'll let you know, okay? You choose to record this. We're not consenting.
This is public building. I don't need your consent.
We're not consenting for you to
This is
record
are you on duty as a public officer of the state of Texas? If you are, then we can move on.
Just listen, Mr. Whitfield.
Mr. Martin, I don't want to hear any nonsense. If this is a public building open to the public, and I'm talking to you in your official capacity, not your private capacity, I don't want to hear anything else on that issue.
Well, whether you want to hear it or not, it's going to be said anyway.
You can do that in the United
Okay,
States.
I understand that, but you're not controlling anything here, okay?
Miss, you invited me here, did you not?
Listen to what I'm saying. Okay, that you choose. We're not going to stop you from recording it, but I'm just letting you know no one else in this room besides yourself.
I've been trying to educate. You don't need.
Let's move on.
Okay.
Okay, basically, I want to make sure that you understand all the conditions of your parole.
I don't understand any conditions of parole, Mr. Martin.
We're talking about your conditions.
Again, sir,
I have no idea anything about your special conditions of parole.
Mr. Martin, would you give me a second, sir? Set a predicate here. I'm Ronald Dwayne Whitfield in the Texas Department of Criminal Justice Institution Division under the so-called supervision of the executive director who has hired a director whose first name is Pamela. Today is February 6, Tuesday, 2018. Mr. Martin is informing me something about parole conditions. I've already informed Mr. Martin and others that, and also talked to the judge's office today, that in order for them to exercise control over my person, I understand you think that I am under the supervision of the department.
Mr. Whitfield, we're not considering this.
You want me to hear what you have to say, correct?
You're recording it for your own purposes. We're not considering this.
No, not for my own purpose.
So just be quiet. Be quiet, please, while we go over this with you, okay? Just be
Mr. Martin, have you shown authority?
As soon as you leave here, you can make all the recordings you want.
Okay.
We're not considering this.
Mr. Martin, one last thing then. One last thing. May I say this? One last thing. This is what I'm trying to get clear here with you, sir. You have a piece of paper that says a judgment and sentence. And therefore you think because of this piece of paper, I am under the authority of the Texas Department of Criminal Justice Pardons and Parole Division, who is headed by a director appointed by the executive director of the TDCJ. Because of this piece of paper that you call a judgment and sentence, you think that these individuals here have legal authority over my person. Now, because I'm clearly telling you on a recorded video that you have no judgment and sentence. And there's only one way and I'm almost done. There's only one way, because this is a challenge. This department is under what we call a quasi-judicial. It exercises those kind of functions. Now, because I'm telling you that what you receive purports to be, but it's not a judgment, then that means you're under a duty to contact the Harris County District Court's office and to determine on whether or not what you got is what it purports to be. If you understand that, I am listening to you.
Okay. Now, the reason you're here is because we do have jurisdiction over you.
Objection. I beg to differ.
Based on the fact that you're on parole.
How?
And then we have this parole certificate confirming that you are on parole and we have jurisdiction.
I don't dispute that. I'm disputing you having no authority.
All right, Mr. Whitfield, you said that was the last thing you were going to say. Be true to your word, okay? Now, from now on, you just need to listen to what we're saying. Okay?
You misstating facts, sir. That's why I interpose.
Not only are we going to go over your certificate, but we have another issue we need to review with you. And if you continue to interrupt and talk, you're going to be here all day, literally. So we need to move on. Okay, you made your point. We've been very accommodating to you. We haven't interrupted you or anything like that. So you need to do the same.
I am, sir, but
You're the one that's continuing.
Okay, fine, but you misstating facts. That's why I interpose. You do not have authority. You talking about a parole certificate as opposed to a judgment where that authority is derived.
Okay, Mr. Whitfield. Like I said, I'm going over your parole certificate at this point.
Objection. For the record.
Okay. Name is Ronald Dwayne Whitfield. Basically, you're on parole at this time. TDC number 623-668, state ID number 038-39853. And basically, I'm just going to go over your statutorily mandated conditions. If you have any questions regarding those, then we're going to go over your special conditions. Okay. Your mandated conditions basically say unless otherwise provided, I shall reside in the county.
Excuse me, Mr. Warren. I can start rehab, but you have a very important phone call, so I can't take that over while you get back on the call real quick. Your supervisor.
Yes, I agree with that. And it's not special.
Okay. So, statutorily mandated conditions. Unless otherwise provided, I shall reside in the county in which I resided at the time I committed the offense for which I was sentenced to the institutional division, or the county of the offense for which I was sentenced to the institutional division if I was not a resident of the state of Texas. I shall demonstrate an educational skill level that is equal to or greater than the average skill level of students who have completed 6th grade in a public school in the state of Texas. I shall submit to testing for alcohol or controlled substances. I shall not communicate directly or indirectly with the victim, go to or near the residence, place of employment, or business of the victim, or go to or near a school, daycare facility, or
Objection, ma'am. I'm going to call for an attorney. I don't want to hear all that. I'm going to ask for an attorney.
The victim is in attendance. I shall not intentionally or knowingly communicate directly or indirectly with, nor intentionally or knowingly go near a residence, school.
Miss Washington, I do not care to hear that.
The offense for which I was sentenced to the institutional division.
Brandy, are you ready to go?
I shall reimburse the state of
Are
Texas.
you ready to go,
for the
baby?
cost of
Because she's
the
not
post-
listening. I don't want to hear
The
that.
problem is you're not listening.
I don't want to
But
hear
we're not
that.
going to hold you. If you'd like to leave, you can leave.
Come on, Brandy, get your purse.
Have a great day.
Let's sign out, please. All right. What time is it? What time have you, ma'am? What time is it? Thank you.
Okay, after time.
Okay. Brandon, go to the common menu as we go. Okay, I was Ron Dwayne Whitfield. I was here on yesterday. I just told these people, I want to use another word, that they have no authority over me. I don't care about a parole certificate. You don't care about a parole certificate, meaning them. Only thing we care about is whether or not you have authority. Authority. If you don't know what the word authority means, then please consult the Black's Law Dictionary. Any addition for the term authority is akin to jurisdiction, but there is a slight distinction. They do not have authority over my person. The only way you're going to prove authority is through a judgment and a sentence. It's the only way you can do it. On file. Not just happen that you just happen to receive, but on file. Without a judgment and sentence, I'm not a parolee. You don't have authority over me. They don't have authority over me. Now, if I got to die, or God, whatever happens, that's what's going to be. I mean what I say, and I say what I mean. Unlock. You want to smoke a cigarette before we go, wife? Huh? Okay. That's the problem. Notice how the way I was taught in books, and the way I was educated, is that you allow a person to explain what they know. Once you understand that, I forgot what kind of appeal it's called, but I learned it in philosophy and English grammar books. When someone has an issue, which I have, I'm challenging your authority on the ground that you're telling me that I'm a parolee and you have authority over my person, then you have to allow me to state what I have to state. And then the appeal process goes that you will reiterate what I have said, and the purpose of doing that is to make sure that you understand my position and what I have stated. Once you have done that, only then can you be in a position to respond. Only then. Only then. Because they do as they do, this opens the door and leave room for them to claim that they didn't understand what I was saying. You understand what the hell I'm saying. I've been telling you from the beginning. You don't have a judgment. That's the only way of course you want to do all this here. Of course. Why? Because I'm attacking you legally. You need a judgment. Brandon, can you get that thing and so I can plug my phone in? Well, I deal with it. You need a judgment and sentence. Me and my wife, we can't do what we need to do in life because of what y'all doing. That's gonna stop. That's stopped. Instead of telling them, as if they don't know, you can challenge authority. You telling me about what he's talking about, a parole certificate. All that is a contract. Now, I'm challenging that contract as not being valid because it is issued based upon something that does not exist. Does that make sense? The only way that I can be transferred to the prison system, and the only way that you can exercise authority over my person, go ahead. I'm recording. Huh? Well, then determine whether you should say it then, because it's going on YouTube. I have to put a stop to this, Brandy. I can't go. I got things in life to do. And it's the reason that they do not, and want to say cannot, but they must, if that's not a contradiction, address the matter, is that it's going to destroy the state of Texas. That's why they are doing what they doing, because it's going to destroy the state of Texas. That's why. That is exactly why. Meaning, they didn't put all these people to death out of Harris County. And they got all these people incarcerated out of Harris County. And none of these people have a judgment. None of them. Now, I've called the Harris County District Court office, and I've also made videos proving what I claim. Now, you should ask, why is it that they don't want to hear that? If I challenge and I have your authority, the only one, and I'm finna end this video, but I'm making it for my family and those people to help me. That's why I'm doing it. They don't have authority. Everybody in the state of Texas, and I guess every other state in the United States, are put to death or incarcerated based on a judgment and sentence. That's the authority to put a person to death, and that is the authority to confine a person. The sentence is that part of the judgment that orders the punishment to be carried into execution in a manner prescribed by law. See Texas Code of Criminal Procedure Article 42.02. See Texas Code of Criminal Procedure Article 42.01, Sections 1 through 8. Also see Texas Code of Criminal Procedure Article 37.12. And finally, the law that gets a person placed in confinement in the Texas prison system is Article 4209 of the Texas Code of Criminal Procedure. That is the law of the prison system. It tells the director of the Texas Department of Criminal Justice that he or she shall not take a person into his or her official capacity until he or she receives the judgment and sentence of the convicting court. So do that make sense? The law tells him or her, the director of the Texas Department of Criminal Justice, you shall not take me into his custody unless you receive a judgment and sentence. So the director received what he thought was a judgment and sentence. I get the shit. That's not what that purports to be. So you're going to ignore me? There's nothing on the face, front or back of that instrument that shows that it came, even shows that it came from the Harris County District Clerk office. Nothing on the face of it or the back of it. And I've got an original. I've seen the original of it when I used to go to the Harris County back in 2015. There's no file mark on it, and there's no a seal on it or anything else. But that's the instrument or thing itself. You need a record that it exists, which is the docket sheet and the minutes of the court. And they know that. You need a record of that so-called instrument. Now I refer to it as an instrument. If that thing were on file with the Harris County District Clerk for that case number, cause number 617718, say it again, cause number 617718, on the docket, well, it's not, see that, for cause number 617718 from the 174th Judicial District Court of Harris County, Texas, if that instrument, what they think is a judgment, had been filed and therefore on record, it would be noted on the docket sheet as filed, just like the complaint and just like the indictment and every other order in that case. Everything that they file has to be documented. And this is what I'm making clear. If a person has been convicted of a crime, you need a record of it. There must be a record. And they want to get around this here because they didn't put a lot of people, so you can see why they doing what they doing. They don't want to be exposed. The governor don't want this to be exposed. The Board of Criminal Justice, they don't want you ass gonna be exposed. Y'all keep on playing testing God, which I think it does not the Bible say do not test the God? Well, it says do not test the Lord your God. That's what they're doing, testing God. That's dangerous. I know. If I've never made any other video clear, I've made this one clear. You need a judgment and sentence to exercise authority over my parole. We got a parole. That ain't shit. That ain't shit. I'm just being real. You need a judgment. That parole certificate has to be based upon a judgment. Once I challenge what it is as void, not void, but the parole certificate is void. Well, we need to lock you back up. You can't do that either because you never had authority. They never even found proper. The judge on the record shows I was arrested without a warrant. Therefore, Texas had 48 hours to get me before a magistrate for probable cause. Failure to do so, you have to. My release is automatic as an operation of law. They didn't do that. You have to do that. You got to find. The Fourth Amendment says that the God-given right of the people to be both secure in their person, places, and effect against unreasonable searches and seizures shall not be violated. And no warrant shall issue but upon probable cause. So issuing warrants to the sheriff of Harris County to detain me without making final probable cause is an offense. That is a duty that is imposed by the federal Constitution, Fourth Amendment, upon a magistrate to make. You have to make a final probable cause because none was made. But the point is, every act, everything filed. Nor is there any. And then they got in the record that probable cause was waived by who? A docket entry. There's no order, nor can a judge waive a duty to find probable cause. That's something done. That's constitutionally mandated. Can't waive. I know that. Surely not saying I waived it. Hell, I don't even know. Didn't know what probable cause was back then. So that these people here, they the one. Yes, they got a reason for doing what they doing. They don't want to be exposed. If I were a criminal and I had committed a bunch of rapes or whatever crime, I too would not want to be exposed. I want nobody to know about that. That's going to get me locked up. And that's what they're doing. They don't want the world to know that all them people out of Harris County been put to death and all these people out of Harris County confined without a judgment. Nothing that what you might see on the Harris County District Court website or any other website, that's not the record itself. If you see judgment, conviction, that's something that they've done since the internet has been out. That's not the record itself. The record itself for any court is its docket sheets in the minutes. They cannot show anybody. Man, I'm getting upset here because look, again, for cause number 617718 from the 174th Judicial District Court of Harris County, Texas, the first thing you see filed on that docket sheet was a complaint. So when you go to the box where they keep these documents or records, you will find that in the box. And therefore it exists. That's authentic. That's real. That's evidence. Next you look, you will see on the docket sheet what is called purported to be an indictment. Now, if I want to attack it, that's something you do through the courts. In my case, I'm not attacking what they call a conviction. I'm not attacking what they call a judgment. I'm not saying that the judgment is void. I'm not saying that the judgment is voidable. I'm saying the motherfucker don't exist. Therefore, apart from the court, his name will probably try to come in. He supposed to file an application for writ of habeas corpus. No, because I can't. That's if a judgment exists. The way you know whether or not a judgment exists is the record of the court, which is maintained by the Harris County District Court Clerk. You call the clerk and you ask and you say, nah, I ain't talking about what you see online, which y'all got imaged in the system. I'm talking about the proof of it. The proof, just like when you go to claiming that you broke your leg in Walmart and he's responsible, they're not going to award you any money because you say so. You have to prove it. So it's the same way with this. When someone is claiming to have authority for detaining you from your liberty, they have to show authority. Here's the judge, that ain't shit. What does it? They have to have a record of that. There's no record that the judge file a judgment with the office of the clerk, documenting that I've been convicted of any crime and carried into the minutes. That's when it's carried into the minutes. That's when it becomes effective and enforceable. You cannot enforce something that's not been entered. Those are, I can't say it enough. Those are the official records of the court. It's minutes. Google it. Go online, see what the minutes mean. Texas Code of Criminal Procedure, Article 4201, Section 1, specifically states that to become a judgment, and this is so problematic for Texas, that the law defines what constitutes a judgment. It is not something just merely signed, a piece of paper. It is the written declaration of not the judge, but of the court itself. But it is signed by the presiding judge or the trial judge. But still further, to become a judgment, it must be finally entered of record, not in a box, but on the minutes of the court. Then it comes to life. Then it says before a judgment comes, it has to be filed as a record of the court. File it. Who received it? Who hands did it come into the custody of or possession of? What's his or her name? Note it on the docket sheet so we'll know that it's in the record and that it exists for record. That's what they have to do. Then you can issue it to the prison director to put a person to death or to detain a person for a punishment through a sentence. I know damn well lawyers that are hearing this know I know what the hell I'm talking about. And then even so, I tried to take an appeal. They call it an attempted appeal because you can only appeal from a judgment. A court of appeals cannot no one else can too, directly attack a conviction if there be one. This is something that has to be done through what is called a judgment. So when a court of appeals, a higher court, agrees that error did occur in the lower court, it overturns that portion or part of that court's judgment, the lower court's judgment. It don't overturn a conviction, it overturns that part of the judgment pertaining to that conviction and remains for a new trial. The other portion of the judgment but if a new trial is granted, then that judgment is ineffective, it's set aside. Sometimes the conviction is allowed to stand, but the punishment is unlawful. So they vacate or set aside and order a new punishment. And that punishment affects the so-called sentence. So first there has to be a conviction before a person can be punished. And before a person can be, and the only thing that can cause the punishment to be inflicted is what is called a sentence. A sentence is a simple order. Tells prison officials to either how long to detain the convict or the offender or whatever you want to call that status assigned to that individual. But certainly that person is no longer a defendant. He or she becomes what is called a convict. When you get in the prison system, your status will change to what they call a prison. Today, Texas refers to these people as offenders. I just want to make sure that there's no rule, because you heard her say I violated parole by walking out. So that's why I'm recording. So get this all over the world. I'm steady telling these people, they won't hear it. They don't want to listen to me. I'm here to expose you. Of course you don't want to, but you have to, because I'm not a damn fool in that way. If you ain't got nothing to hide, then you have to do your job. At no time have you told me you can contact the Attorney General. At no time have you told me you can contact the Harris County District Clerk. You keep telling me about a parole certificate. Everybody got the right to challenge. Going to the court. Now, if I was saying that it was void, the judgment was void. I'm not saying that it don't. See, then I would be saying that it, although it exists, it's void. Well, that's something you have to challenge on an application, a direct appeal, motion for new trial, or application for writ of habeas corpus, discretionary review, things of that kind. You go through the course here. I'm saying it don't exist at all. In that case, then, see, the reason why I'm able to say it don't exist because they're telling me that I have to do these parole matters. I'm on parole. I'm telling you, no, I'm not. So what? When you sign a contract, a parole agreement, in return or in response, I tell them that that's not a valid parole certificate. The courts cannot say it's not valid because it came from them. They the one issued the parole certificate. So they declare whether or not it's valid based on what? Why do you challenge this certificate is not valid? Because it's not based on the judgment. Then that means they have a duty to determine whether or not, if the judgment is valid, then this parole certificate is valid. And all the conditions therein, if the judgment exists. I'm not saying that it's void. I'm not saying that it's voidable. I'm saying it don't exist. It just purports to be a judgment. Shit. It purports to be. What does the word purport mean? It appears to be one, but it's not. Appears to be one. I'm telling you, I'm not finna keep being subjected to unlawful control and authority when none exists. Okay, let me call this United States Attorney back because look like he's jumping ship on me in the middle of something. Let me get this on YouTube so I didn't show the world. It is my hope that whoever sees this video take steps to make sure that it never get taken down, that the world knows what's going on here. I'm here to bring down Harris County, the state of Texas, for what it has done to me and trying to continue to do. I can't have a real relationship with my wife because of these problems. It has to stop. I'm wanting to address. You don't have a judgment. Let's be done with this. Let us be done with this. Man, I need to go to Barbara and tell them what they finna do. I need help. I'm tired. I'm telling the world I'm tired. So what, you want to go to the detention for a while? Can you call Barbara and see if she's at home? I keep telling these people, it's a nightmare. I've been dealing with this since 2004. You know I'm tired. No court has ever addressed this matter because they don't want to. Even the Texas Court of Appeals, these judges serve for the state of Texas. They don't want this to get out. But thankfully, now if it was back in the 70s, I couldn't prove nothing. But thanks to the internet, World Wide Web, I'm not just alleging something. I'm proving it. The only thing is that they are oppressively trying to keep me silent, trying to make it appear that I need mental health and all that old kind of stuff. You motherfuckers need mental health. You the motherfuckers got something to hide. I'm free. Meaning, I'm out here still doing what I was doing in prison. They want it to go. No, it's not going to go away. So y'all either going to kill me because my family ain't going to just let y'all get away with this here. The world, y'all just can't let them get away with this here. They can't. You got to address this here. Lock these damn judges up. I went to them. I keep telling them. They know it's not a dispute. It's not disputable. They know there's no doggone judgment, as this is in cause number in the first Court of Appeals and docket number. Well, let me do it right. In what was called an attempted appeal, Whitfield versus State, 01-92-00617-CR. You can go online and see the docket sheet. you'll see an opinion was issued, and you can click on it, and you can get to see the opinion. You'll see a mandate was rendered, filed, or rather, not rendered, but filed. Well, file and render means the same thing. It's synonymous. You'll see a mandate, but you won't see a judgment. It is the judgment, not the opinion or mandate, that finalizes, or rather, affirms or vacates or sets aside the action that has been taken by the appellate court, the lower court's judgment. Only a judgment can vacate or affirm. So in other words, if the first court of appeals had issued, or rather first rendered or filed a judgment in that appellate case, then the mandate would be valid. Because a mandate issues in conjunction with the judgment. That's when the mandate issues. The purpose for the mandate is to finalize the appellate court's own judgment. The appellate court never issued its own judgment. So that means that nothing is final. Everything, you can't put a person to death until the appellate process becomes final. Does anyone know what that word final means? The game that we had, the Super Bowl, the last score during the period of the game finalized that game. Until that game was final, anything can happen. Until an judgment of a trial court or a court of appeals become final, it can be changed. So you don't punish a person by death or by incarceration until the direct appeal review is finalized. The very fact that the court or the justices of that court did not render their own judgment to affirm the lower court's non-existent judgment should tell them God has a different plan about this. They don't want to do God's will. They want to do their own will because they don't love or believe in God. If God had wanted just not to be this way, it wouldn't have been this way. You can't unchange that which God has foreordained, God's foresight, his foreknowledge. I'm bringing to your motherfucking attention that you don't have a judgment against me and you can't ignore. This is something you ain't gonna ignore. You can't. Look at John in the Bible, meaning the chapters 14, verses 16 and 17 and 26. You cannot ignore this. It will not go away until you admit you have no judgment. Admit it. You got to admit it. You got to acknowledge you do not have authority over my person. I'm not. The judgment, if I were, even though I was not, or were not, convicted of a crime, as the Court of Criminal Appeals stated in a case style ex parte Rollinson, 958 SW 2D at page 198, Texas Court of Criminal Appeals, if I were convicted of a crime, it did not become final, and it will not become final until a judgment which contains the punishment and sentence has been what we call rendered. Rendered in Texas means filed. In Texas, in criminal cases, a judgment is not orally rendered. There's only one judgment, and the judgment is the decretal portion. What is ordered? What is adjudged? What is decreed? In rendering a judgment in the minutes, it would recite in relevant part, it is ordered and decreed by the court that the defendant, Ronald Dwayne Whitfield, is a judge guilty as found by verdict of the jury, and that he be punished in accordance with the jury's verdict or the findings of the court, period. Then it will be signed in the minutes, signed by C. V. Milburn, presiding judge. That is the official record of the judgment. That same, then there's what we call a formal judgment that will reflect what is in the minutes. This is what a trial judge will sign also, and file it with the clerk of the court for record, for future reference. So when someone, so to prove it, that's the record of it. I'm sitting up here telling all these people this, and ain't nobody trying to hear me and shutting my voice off. They want to deal with me by locking me up and killing me or murdering me to avoid the legal inevitable. See my treatise at Prophet, or rather Last Prophet Ronald Dwayne Whitfield at casetext.com, which is a complaint filed not only with the United States government and the state of Texas, but also in the world court, in the criminal international court. But I learned after filing it there, or bringing it there, that the United States has no treaty because someone that worked for President Bush Jr. Pulled out of the wrote to the to the assembly or wherever they had to write, and requesting that it was the intention, a future act rather, of the United States to withdraw our signature from the treaty, so that people like me or you cannot bring a complaint against these people that I'm trying to bring a complaint against in the world court, because we don't have a treaty. We're not one of the nations that signed on with the United Nations, so that things that action taken by our government cannot be prosecuted in the world court. We're not a party. But we were a party. I think my research showed President Clinton signed the treaty, but President Bush pulled out. And so that's how that went. I know the government of the United States cannot do that. And then not be, especially, the language of that letter, it's in the Supreme Court of Texas, and I guess the United States Supreme Court too, talk about when you when you sign something, the language used in that letter to the person to pull out of the treaty, it imports a future action. It is the intent or the intention of the United States to no longer be. No. You have to use express language, such as, you are hereby informed that the United States withdraws today its signature that will import a present intent, not something in the future that you might change, or if something go down, then you'll point. Well, we had told no. It has to be clear, leaving room for no doubt. You are hereby notified that the United States, as of this date above, has withdrawn, would even be better, has already done it. By the time you receive this letter, it may be 7 days later, but as of January 6th or whatever, 2005 or whatever, we no longer are in this treaty. So you may get it a month later, but so if something went down, this withdraws it as is effective as of the date of this letter shown above. And the signature, the name on the document authenticates the action that has been taken. So I guess I'll call the United States Attorney back, and then I want the world to see that if they're not gonna protect me, I'm telling them what they plan is. Now, this will let me know whether or not the United States government is gonna let this go down, because they looking dead to get me back in prison. They know what I'm gonna do. They know I'm finna stop eating. I'm saying it right now, so it'll be clear. They locked me up, telling everybody. Yeah, Brandy. Come on. Who is JJ? Brandon, give me the cash so I can go pay these bills. Yeah, so this guy, so the United States Attorney, he gonna kick me to the curb while I'm on the phone with them. But yeah, on the other hand, the Assistant Attorney leading me to think that he's gonna be taking steps. I don't have the United States Association, boy, them people ain't finna do nothing. I'll go there, but I don't have them. The private attorneys. They'll be told to stand down. The FBI supposed to step in. They don't want to do their job. Come on, baby. Every night, I can't, have a regular, normal relationship with my wife because every day is about going to this court. Every fucking day we've been married. This woman's been with me and a guy. We don't get to do nothing but do what I need to do, and that's go to the goddamn courts. We can't goddamn do a motherfucking thing. Nothing. We can't do anything. And they're not, so I'm tired of it. I'm tired of it. If you looking at video, this woman has been with me, my wife, Brandon, has been with me through thick and thin. She's always been there. It's time for us to go on with our life. Somebody out there got to love and fear God. That's in power. That I didn't put Texas in the position that's what they get for being so stupid and stingy. Wanted all the money. They don't want to buy a fax machine. Look at, as I have, ruckus from the Supreme Court, and they no, baby. We're in the traffic right now. Let me finish this here. Maybe when we leave JJ. Yeah, I think you can take over from now. Well, so what? You still driving? Like I said, the United States Attorney, he want to kick me to the curb. So it's up to the world to help me. Go ahead. Put this on pause.
Hello. Ever get in touch with MHRA? Do you know what's stopping you from getting in touch with them? Okay, I just want everything to be done before the court date. Okay, so if you have any issues, let me know. Okay, thank you.
Call the United States Attorney again for me. I like the way you did that. That was you there. All you. I know that must have messed her up. But see, nobody have to keep going through evil. No, I'm not on no damn parole. They want to do all the talking. So you can show that itself is official. Did you get it? The United States Attorney back. United States Attorney. His name is Mr. Adam Goldman.
United States Attorney, Mr. Adam Goldman.
Shit. They don't be slow to lock your ass up. I'm steady telling them, so nobody can say I wasn't very clear. I have not said, and nor am I saying, that this so-called piece of paper is void. I told him it don't exist. Can't say can't say it enough. Now if I'd have been George Bush's son or Bill Clinton's son, baby, go look in your menu and dial that. You'll recognize the call from when we was at parole. Depending on who you are determines whether or not due process is allowed. I haven't been under Texas law. I haven't been convicted of a crime, but that's something I would have to take up with the court. Right now, my only argument and position is that apart from whether or not I've been convicted, that is not in. That's why I'm going on a food strike. Hello? Hello? Baby, that didn't go right. Look at that. That wasn't the right number. Something. Help me, baby. Don't. This is very important. You heard me. They finna lock me up. So I'm trying to stop that. That's what this is about now. Yes, ma'am. I need to speak with Mr. Adam Goldman. His name is Adam Goldman. You said JJ, right? Okay, what's the problem? I'm watching that. Got a mirror, I'm looking. Turn the okay. You hear that? I mean all this beeping in your phone. Oh, hopefully that's their system.